Good evening, everybody, and welcome to the Tuesday night edition of the People's Show. And of course, Tuesday night is our legal hour. We're here with Mark Wallace, your host and facilitator, with you every Tuesday night. Joining me by, in just a few minutes, is going to be Cook County Circuit Court Judge Leonard Murray, who is a sitting judge. So you're going to get a chance to talk with him tonight. You'll be able to call in and ask your questions. You'll be able to call into our calling number at 951-221-8221, 951-221-8221. So that is our new calling number that you will be able to call in, and you will be able to ask Judge Murray your questions. Again, our telephone number is 951-221-8221. You'll get a chance to call in, and you'll get a chance to ask your questions. You no longer have to write them in the chat. Well, you can write them in the chat if you just don't want to come on. But I would hope that you would want to come on and that you would want to have a real conversation with me and the judge, for that matter, to answer any legal questions that you have. Now, any of the legal questions that you have, of course, the judge cannot give you legal advice, but he can certainly give you answers to your legal questions. All right? So make sure that you're not asking him to give you advice or direction on a pending case or a particular legal situation that you're at, but you can certainly ask a legal question about the process. And so tonight, our conversation is going to be very much about the legal process. We're going to talk about disciplines of the court and what you should know about the court process, questions that you might have about the court process, and how you get into in front of a judge if you have an issue that you might have a dispute with somebody over an agreement or something that they were supposed to do, or you had a contract agreement with, and that person did not fulfill their part of the contract. Then I'm going to share with you what steps that you need to take to file. We're going to tell you what the difference is between a pro se, what that means as a pro se, or the difference in having counsel, and why having a counsel is important to do, and does the court defer to counsel rather than people first, rather than those people who actually have a case and they are representing themselves? Is the court deferring to the people with attorneys first? So all of those questions that we have, all those questions that you have, you're going to be able to ask the judge those questions. All right. So now, if you have people who you know that have been tuning into my program on X, we are no longer broadcasting on X because X now wants for you to, in order to broadcast on X, formerly Twitter, Elon Musk, who is now the owner and CEO of Twitter, and I just refuse to support Twitter and or X, so we're no longer broadcasting on that medium, and I refuse to give what I consider to be a divisive, known racist and bigot any money. So if you know of people who have been trying to get on and through Twitter, let them know that they can go over to my YouTube channel. Just look for Mark Wallace, The People's Show, and you'll be able to pick it up right there, and you'll be able to see the program. All right, so certainly want you to be a part of the show. So just look for Mark Wallace, The People Show, and you'll be able to tune into the show wherever you are in the country. All right, so and then I would like to ask if you would please register. Please register on the podcast, and there is no fee. All right, there is no fee, so we certainly appreciate that you would be a part of this program. All right, so while we wait for Judge Murray to call in, or certainly to sign in, we're waiting for him to join us. Then you can actually call me. You can call me now if you'd like to. If you got some comments, our telephone number is 951-221-8221. 951-221-8221. This is our second week with our new call-in system, so we're just getting used to it, and we look forward to certainly having conversations with you and dialoguing with you. We are looking forward to the convention coming up. The Democratic National Convention will be here in Chicago next week. It is going to be an exciting convention with now into almost a month. The Vice President of the United States is now the nominee. Certainly, she has secured enough delegations or delegates, and to have become the nominee for the Democratic ticket, along with her running mate, Tim Walz. It's an exciting time. It's an exciting time. It's an important time. And we have to do all that we can to make sure that we are saving democracy where we will actually have a fundamental basis by which we can sit and we can debate and we can discuss, we can disagree, and we can solve problems through that democratic process. But we cannot allow for our democratic process and the democracy that has been churning and has been developing and has been improving and being challenged for the past 200 plus years to be overturned by some people who believe that their way is the only way, and by turning the clock back and to having trying to amass a few people who feel like they are disaffected, and they think that the only way to challenge that is to join forces with people who are actually interested in being disruptive. The way that democracy works is that when you don't like something that is happening, when you are when you want to see change, then you get into the democratic process, into our democracy process, by either contacting representatives, the representatives that represent the districts, whether it be local city council representatives or mayors or Cook County Board commissioners or Cook County Board presidents, or your state representatives or your state senators. That's what we have, is a representative government. That's what our democracy is. We have elections. There are people who register and collect signatures to become candidates for particular offices, and we elect those people and we vote for those people to become our representatives. So they become our voters on policy. And if we want to impact policy, then we need to have conversations with the people who we have elected to be our representatives. If we don't like something, then we contact them. If they don't get in contact with them, we send them emails, and they're not responding to us, then we organize ourselves together and we we demonstrate. If we have to protest outside of their offices, then that's what we have to do in order for ourselves, for our voices to be heard. But you have this group of people who are working with the Heritage Foundation and ALEC, which is the American Legislative um, um, Exchange Commission, that just want to blow up the process. They want to roll back any progress that is being made. And it is rather foolish, it's immature, and misinformed of anybody who thinks that the best way to do that is just to blow it up. There are some things that should be changed, but we have a process by which we make those changes, and that we ensure that people's voices are heard, and we make sure ourselves that our voices are not taken for granted. So that means that we have to do a better job of organizing ourselves together, making sure that we are putting forth the ideas of agendas and policies that we believe that need to be met differently than maybe they are. Then we operate within that democratic process. What they're talking about doing with Project 2025, which I'm not going to get into a lot tonight, what they're talking about doing is completely destroying our system that people have bled and died for. That you now have these people who are joining this this agenda, this effort, whatever you want to call it, to come completely upend that. When they're talking about things like getting rid of civil service workers, making it easy to fire people who have spent their entire careers working and serving the country, to making sure that our democratic process is intact and getting better. And now you have a group of people who say, no, that process, we can't have that process. We have to have a conservative movement, that we destroy that process and we put in the people who adhere to our ideals. That's what this group has done. We also want to talk about it. There's a story that was done, and it talked about Donald Trump's agreement with Egypt when he talked about writing a check for $10 million. Now, he's never going to be held accountable for this, because, and the reason why he's not going to be held accountable for it is because the statute of limitation has expired. But nonetheless, I think it's important that we know about this. And I'm going to I'm going to play that in when we get done with the legal hour with Judge Leonard Murray, because I want you to hear that. Now, if you are on Instagram, we're only on Instagram for 1 hour, and then after that, you can join us by tuning into my Facebook channels at Mark Wallace or The People's Show on Facebook, or you can go to my YouTube channel at Mark Wallace, The People's Show there. And I would certainly ask if you would subscribe to the channel. There's no cost. We just want to make sure that we get our viewers up so that we can certainly attract more participants and more viewers to certainly get our message out and information out to the public. I pay for this. I don't have any sponsors or any paid advertisement. I don't get paid by political interest, political parties, the Democratic National Convention, nor the Democratic Party gives me money. This is something that I fund completely out of my own resources, and I'm happy to do it. Now, there may become a time where we may have a capacity that we will attract sponsors or advertisers. However, whether that happens or not, nobody, not advertisers, not sponsors that want to be sponsors of this program, will dictate or compromise any content that we put out. And we intend to continue to put out the facts, the information, so that we all can be better informed about issues that are important and pertinent to us to date and for our future. And that will not be compromised. And we will hold to account those people who are responsible for being our representatives, be it Democrats or be it Republicans. If they're in a Democratic Party, which I am a member of the Democratic Party, or if they're in the Republican Party. Our job is to make sure that we put information out. Our job is to make sure that you get the facts over the fiction. Not interested in having, sensationalism to attract eyeballs through just, foolish rhetoric and name calling and that sort of thing. I've never been about that, even when I was on radio. That's not what I'm about. Now, I will certainly call people out. And you've heard me be very critical of certain people. And for a long time, I was critical of Ed Burke, long before, who was the former alderman of the 14th Ward. He's been in the longest serving city council person. But I've long said that that person was a criminal, that he abused his office, and I believed him to be a bigot and a racist. And for the longest, I didn't understand why there was this alliance to him by people from the Black community. And I was very critical when I was on air on WVON. And I was on a program that was, or is, I guess, still hosted by Ernesto Borges. And we got into a discussion about Ed Burke. And he thought that I was being rather critical of Ed Burke, which he has every right to his opinion, as I do my opinion. And I said, yes, I believe him to be a racist and a bigot and I believe him to be a crook, that he's abused his office, the office that he represented. Well, he got indicted and convicted on more than 12 or 14 counts. He is a convicted felon. He's a convicted felon of what I've always believed him to be. And I thought that it was very strange that a black organization, I don't know what it is they do, but supposedly they've been around for a very long time, and they made this person an honorary member of this black organization, which I just thought was absolutely unthinkable, to have someone who treated the black community and certainly treated Harold Washington and started this vicious rumor about Harold Washington's sexual orientation in order to destroy that person's administration or ability to lead their administration, none of which was true. And had people actually believing that. They actually had people believing this. And it was the furthest thing from the truth. And it all sparked because of the former alderman, Ed Burke, who made the accusation. I'll pull the article up of the reporter who actually wrote the story. And I believe that was the medium that it came from, the reporter. But at any rate, so we were talking, and on one particular Sunday, he actually brought it up. I didn't even bring it up. He brought it up. And so then, of course, I stated what my opinion about that was. And my opinion was that I thought that it was crazy that they had him as an honorary member of this all black organization. And he took exception to it and stated that, yes, he is a member of our organization and has been. And I said, well, I question the judgment of your organization. And so they took offense to that. And of course, I never went back on that program, which is perfectly fine because it's his program. And anybody who has their program has a right to have on their program whom they choose to do so. And but I said all that to say that this program is 100% funded by me. 100% funded by me. I don't have sponsors. I don't have advertisers, and I'm perfectly okay with that. And nobody will be able to compromise anything that I want to share or say. But I am certainly, it is my intentions that I provide you with factual information that you will be able to verify and that you will be able to use in terms of making decisions or understanding how things work within our social, political, and our social economic situation. And so I work hard to bring you information. And if we can provide a little entertainment in bringing you that information, so be it. But we're not here to be sensationalists, and we're certainly not here to be compromised. All right, so that's what it is. And so in our second hour, we're going to be, I'm going to play a couple of clips for you. But right now, joining me is our weekly guest, legal guest, is the Cook County Circuit Court Judge Leonard Murray, who is joining me right now. And he is here with us. Hey, Judge, welcome to the program.
Good evening, Mark. How are you doing?
Doing great. Doing great. So we're getting closer to the DNC getting here. But tonight, what we wanted to do is we want to concentrate on talking about the process of court and how people get into court and what that process looks like, and things that they should know and how they should prepare themselves if they are going to be coming to court, and certainly if they're going to be representing themselves, what that's called, um, and what what that process looks like, and some tips that make things um, work smoother for the average person who is at some time or another in their lifetime is going to be before a court. So we want to equip people with that information of some things that they may not know. So we want to share that with them tonight.
Okay, well, it's important to know that there are principally two areas of law. First, you have the criminal law, uh, which is the um, sense of the community um, to punish individuals who violate the sense of the community. And that's why, if you've ever seen a criminal complaint, it always reads the people of, because it's brought in the name of the people. So the people of the state of Illinois versus Mark J. Wallace, for example. I know you've never been a criminal defendant, but it would read as such. And the reason for that is uh, uh, over time, there's certain community norms that have developed. So when someone is accused of violating the community norm, then the action is brought in the name of the people. So the plaintiff in criminal cases, uh, where it involves a violation of a state statute, and it's principally all the criminal violations are violations of a state law. So the action is brought in the name of the people of the state of Illinois versus the petitioner Mark J. Wallace. Uh, and of course, those actions are brought to um, suggest that someone has violated a statute um, that is based on community norms, and therefore the government, in the name of the people, is seeking a sanction or punishment against that person for that alleged violation. Um, there are two levels of criminal complaints: those that are considered misdemeanors, which means that the available sanction is 365 days uh, of incarceration or something less, or a felony, which is a possible sanction of more than 365 days. Um, and of course, depending upon the severity of the crime, then it could be one that takes away your liberty, meaning that your freedom to move around in society is taken away. And in some instances, that taking away of your liberty could be for the rest of your life. And of course, excuse me, there are uh, federal statutes that in the criminal vein that impose similar punishments for different acts. And also, there's some civil action that are prosecuted uh, in federal courts as well. So um, we can talk about those as we go forward. But I think tonight, uh, what we want to focus on is process. So let me start by trying to give a simple example of procedure involved in a criminal complaint. So um, a person is arrested or sometimes given notice to appear, and they show up in a criminal courtroom, and the charges that are alleged uh, violation against them is read to them, and at some point they're required to enter a plea. Typically, is not guilty. Uh, State has a burden of proof in those cases, meaning they have to prove guilt beyond a reasonable doubt. You have a right to trial by jury, meaning you have the ability to pick uh, 12 citizens from the community to sit in judgment of your actions and whether or not that constitutes a violation of the statute in play or not. Um, and that right to jury trial is both for misdemeanor actions as well as felonies. Um, we have also imposed, or at least the development of law is such that in criminal cases, uh, there's a right to have counsel. It's the Gideon principle, so that we don't expose someone who is facing the possibility of loss of their liberty without the ability to have a lawyer uh, represent them. And sometimes, if the defendant elects not to have legal counsel, the court can appoint a court advisor to assist, even though they are not technically acting as a lawyer in those proceedings. Um, and that's both felonies and misdemeanors, although it's seldom done in misdemeanor situation, but it certainly can be done in felony cases. Now, not every state has the so-called public defender program that exists in Illinois. There's some states that don't have a public defender's office. So what they do in those situations is that they will appoint a lawyer that is paid by the governmental entity involved in the prosecution to defend that person, since they don't have a quote unquote public defender office in those situations. I think in some of the southern states that is the situation where they don't have an institutionalized system of a public defender's office. And of course, in the state of Illinois, we do have uh, institutionalized public defender offices throughout the state. Um, let's switch back to the civil side. Um, uh, Civil actions typically involve uh, disputes over money, although there are other areas that can be at issue. For example, um, if you have a tree growing on your property and its growth extends beyond your property line, then your neighbor could file an action to require that that you take necessary actions in order to trim that tree, such that its branches don't extend beyond your property line over to their property line. That would be in the nature of injunctive relief. Now, us use that example just a little and add a little nuance to it. So let's suppose that we got the same tree and there's a storm, and as a result of the storm, branches from that tree are broken and they fall over and damage your fence, the fence that you own on your side of the property line. Uh, then that injury that you have realized or experienced as a result of your property being damaged, something that your neighbor it would very likely be obligated to compensate you for. Uh, in many instances, it might be covered by insurance that's available, uh, by the neighbor's homeowner's policy. Or if not, then you could explain to them that the damage that I sustained, I believe you're liable for. And therefore, if you don't have insurance coverage, you should pay me. And if they refuse to pay you, then you can take them to court to try to collect the amount that you are out of pocket um, in order to put whatever the damaged item is back in the same condition as it was before the damage occurred. Now, if you happen to have insurance on your home, and most homeowners do, you want to transfer that risk to someone else. Uh, uh, if your insurance company compensates you or undertakes the repair themselves, then you would subrogate your rights to recover to the insurance company, and then they would bring an action against your neighbor if they don't otherwise compensate them. And in the caption in that action would be it would be brought in your name as the damaged party, and it would be your insurance company subrogate of you against your neighbor, because you were by them paying the damages that resulted from this tree branch falling. They essentially have satisfied your claim. So therefore, what was your claim then becomes your insurance company's claim, and therefore they bring the action to recover the amount that they advanced in order to make the repair or otherwise compensate you for the damages that you sustained. Now, in civil cases, in order to have an order entered against you, you must be given notice uh, in a lawsuit. The notice of the lawsuit must be given to you. Uh, Sometimes that involves service by the sheriff. Other situations, there could be some alternative type of service that's allowed, but you must be given notice of the action uh, to afford you the opportunity to defend against it. So unless notice has been given in whatever fashion is allowed by the rules, then the court never obtains personal jurisdiction over you, and therefore no adverse order can be entered against your interest because the court has no jurisdiction. So that's typically what happens in the early stages of litigation, litigation at least. Once a complaint is filed, uh, then you must be served. And the issue is how do the rules allow you to obtain service, or is there some special process that the court might allow upon petition in order to give you notice such that the court can suggest that it has jurisdiction over both the subject matter of the dispute and also the persons involved in the dispute.
Let's talk about, let me ask a question there a little bit in terms of service. So someone files an action against another. Party A files an action against another person. That person in Cook County, they pay a filing fee for that particular action.
Yeah, unless you come in and demonstrate that you don't have the ability to pay those fees, and you can be given a fee waiver. It usually requires the filing of a petition, presenting of a petition for fee waiver. We have to disclose some of your financial history and situation, such that whoever reviews those can determine whether or not, in fact, you should be allowed to initiate the action without paying the customary fees involved in filing the case.
So that's depending upon certain criterias that they look at in terms of your economic situation. What about if a person owns a home? Are they automatically disqualified from even though they own a home, they still could find it very difficult to pay fees because some of the filing fees are rather expensive depending upon what kind of case you're filing?
It's not automatic. Judges have quite a bit of a discretion in terms of whether or not to waive filing fees. So I wouldn't say that home ownership necessarily is an automatic disqualifier for the relief of a fee waiver.
Now, is it the judge who makes that determination? Or I know that in Cook County you have to go to, I think it's room 1301, and provide this information, and they make a decision there. Or do you go there and complete that paperwork and it goes back before the judge and the judge makes that determination?
Yeah, each division has a different process. So those cases that are filed in first municipal, um, then you go to 1301, as you mentioned.
Mhm.
Um, but if it's a law division case, they have a whole separate process for the consideration of fee waivers. Similarly, with divorce or chancery, probate, all those divisions have their own cri- not the criteria is similar, but again, it's within a judge's discretion as to whether or not to grant the fee waiver. But each division has its own process for presentment of a fee waiver. Typically, it's likely that it would be presented before the presiding judge of that division uh, for consideration, either by someone they've assigned to do it or by the presiding judge of the division themselves.
What's the different types of you just mentioned the law division. We have the law division, you have the chancery division. How many different divisions are there in the first municipal um, division, or district, I
Well,
should say?
okay. Well, first municipal is in and of itself a division.
Mhm.
Uh, in first municipal, you have cases that typically involve claims that are no more than $30,000. Um, but they handle landlord-tenant disputes, um, uh, jury trials where the amount of controversy is no more than 30,000. They handle uh, what else? The
Foreclosures.
housing section is part of first municipal. Uh, Non-jury contract cases, again, where the amount of controversy is not more than 30,000. Um, uh, there was a time when traffic was part of First Municipal, but I think now that's been removed and traffic has become its own division. Um, but I think that covers it. Housing, landlord tenant, contract disputes, both jury and non-jury. Um, there's a pro se division. It's part of First Municipal.
Pro se. What is pro se?
For yourself. It's a Latin word meaning pro for say self. So those are cases that are filed typically by folks who are not lawyers. Um, Although in theory you could be a lawyer and file your own case,
Mhm.
but essentially it's litigants who are not lawyers who are initiating claims of some sort against someone else. And
So
the
they
amount
would
of
be filing a
controversy there
claim.
is typically, I want to say the amount of controversy there is typically not more than a few $1,000s.
Okay, and a person who is filing pro se. Now, the the court process or the court system is foreign to most people until they actually find themselves in that situation. And as a result of that, it is very intimidating to the average person who, finds themselves in that position, because it's not something that you're going to come in contact with every day. And
Mark, give me 30 seconds. I'll be right back.
Okay, sure. All right. So, um, yeah, so I want to set this up, and when the judge comes back, certainly want to talk about this, because the average person finds that process to be very intimidating. So I want for people to be informed, that they not be intimidated, that once they walk into the court, that the court, the judge, and that process is not against them. But I know that, if you've never been in that situation, it is quite a it's quite daunting, quite intimidating to most people. I've been in court many times. Obviously, um, I've been a part of actions where I have been the plaintiff. Most in most cases, that I've been the plaintiff, and in a couple of cases, I have been the defendant. I've also been involved with cases that have that are class action cases that we have advocated on behalf, and uh, on behalf of a class of people. So I'm familiar with the court system and the court process. However, it is still one that I have respect for. So there is still a level of, I would say, um, not intimidation, but certainly because of the respect that I have for the court. Um, you you know you conduct yourself accordingly, but it is still one of those situations that when we all walk into, there is a little bit of nervousness on the part. So one of the things, Judge, that I think it would be good for people to understand is that when they come into the court, whether they are a plaintiff or the defendant, in particular, if you're the defendant, that the court is not there to be against you, right? So the court is not your enemy, and so the
Yeah,
court is
we're neutral.
neutral, right? It's that
Yeah.
neutral party to hear both sides and to render a just and fair decision that not everybody's going to be happy with, but that's what the court's responsibility is.
That is accurate. We're there to review the facts, apply the law, and make a decision based on what we've been presented with, and also what comes from the other side. What is their response to what's being said, in terms of what occurred. That's why we have trials, so that each side gets a chance to have the day in court, and your opponent presents their side, and then you have the opportunity to present your side. I have presided over 12 double pro se jury trials, uh, which I think I'm far beyond anybody else that I'm aware of in Cook County who's done that many jury trials where both sides were unrepresented. Uh, and I can tell you that one of my colleagues had a policy that if, typically in landlord tenant court, it's the tenant who typically will demand a trial by jury because they think it buys them more time. Um, uh, Not always the case, but that's the belief. Um, but one of my colleagues had adopted the policy that the person who demands the jury trial has to show up on the trial date with the jury instructions. If they did not, he would strike the jury demand. Uh, I took a different view because I thought that was not fair, and moreover, the instructions that a judge gives to a jury, it's the judge's instructions. It's not the party's instructions. They can submit proposed instructions, and sometimes you have an instruction conference where you go back and forth in terms of what each side wants. But ultimately, the instructions that are given to the jury, they are the judge's instructions, and sometimes providing the wrong instructions is a basis for reversal in the case, uh, because it's how the judge informs the jury as to how they should go about deciding a case.
And
But
if someone is not represented by an attorney and the other side is represented by an attorney, does the court look, no, let me pose this. Does the court in any way disadvantages that person who does not have an attorney, because obviously the court, the judge himself or herself are lawyers, and the other side has a lawyer? Does the judge look at the person who doesn't have a lawyer and say, or make some sort of biased because that person doesn't have a lawyer?
that you absolutely should not do that. Uh, Again, the methodology is to hear both sides, uh, let them express themselves through counsel or without, and render a decision based on what you've heard and what the law says. But it should not matter whether or not one of the litigants is participating in the proceedings without a lawyer. Um, you have a right, absolute right, to represent yourself. We cannot force you to have a lawyer. It's your choice. Um, but we do have to follow the rules and make sure that each side, we're not um, disadvantaging one side or the other because they have a lawyer or not. We can't do, but we must apply the rules evenly and fairly to both sides. I have a uh, pending matter now where it's a person that the city is suing in a housing case. He is pro se, and I tried to explain to him that until you answer the complaint, we're not at issue. Because if you don't answer the complaint, then it seems as if you are admitting what the allegations are. Well, I know he's not doing that, so I explained to him that you need to answer the complaint, and it's not hard. Either you agree with what they claim uh, the facts are in that paragraph, or you don't. If you agree, you can say you agree. If you don't agree, you can say I don't agree, and it's really that simple. And unless and until you do that, you're not at issue in a case, meaning you haven't answered it. So you haven't put the proponent of the case on notice that you're disputing anything. So uh, I finally broke through today with this person, explained that uh, you just have to answer the allegations, yes or no. You have no burden. That's the other thing that sometimes litigants don't get in terms of the process, and that is if you're a defendant in the case, you don't have any burden. It's the plaintiff who's brought the case who must uh, sustain whatever their burden is in the case. Typically, in civil cases, it's more likely true than not that what they allege occurred did occur. But you don't have to disprove that. You just have to put on your evidence that doesn't allow them to sustain their burden of proof. But you really have no burden to prove anything in those cases, unless you have asserted an affirmative defense. In which case, if that's what you've done, then you do have a burden relative to that defense. But otherwise, the proponent of a of a of an allegation, they have the burden of proof, not the one who is responding.
What about when someone is filing an action against someone, and of course they go and they file the action, and then they go to the sheriff's department and files for the sheriff to go serve that person, and obviously the sheriff has to serve uh, the other party, and the other party has to be served in order for the court to have any jurisdiction on them. But there are times that people duck service, or that the sheriff is only going to go to that place. Um, is the sheriff required, or is there a basis for people to check with the sheriff's department to find out whether or not they were able to make service? Because you have a court date, and that court date has been set out far enough so that service can be executed in enough time. But if you don't know that that person has not been served in all that time, and you find out when you get to court that that person hasn't been served, so therefore uh, they can't go forth until the other side has been served. Does the
Well,
sheriff
when
have a responsibility of notifying the other side that they were not able to make service?
they don't normally make an outreach such as that to tell you that what you left with us, we weren't able to serve. But they are required to file their return of service. So this is an affidavit that they file that says on such and such a date they attempted to serve John Smith at this address. They'll indicate the date and time that they went and what the result was of that attempt. So if they weren't able to serve John Smith, then they'll say no service. Now, typically the sheriff's office, as I understand it, will make at least two attempts at service in a civil case. So there should be at least one more attempt that they make under at least that service attempt. Now, if both those attempts are unsuccessful, then you then would have to have an additional summons issued that is referred to as an alias summons. So any summons that is issued after the original is called an alias summons. So you could then take that summons to the sheriff and ask again that they attempt to make service on John Smith. And again, they would have to report what their attempts are and the success or non of that attempt in the form of an affidavit that they file with the clerk of court to demonstrate whether or not there's any jurisdiction that has been attained. Now, if uh, that doesn't work for you, it is possible for you to ask the court to appoint what's referred to as a special process server. So that's someone who must be at least 18 years of age and not involved in any such way with the litigation uh, that you can make responsible for attempting service of the summons and the complaint as well. Uh, and that is a private situation. You're obligated, just as you are for paying the typical sheriff's fee for service. Normally, special process services are a bit more, um, but you probably would hope for a better return in terms of their efforts at obtaining service because they
So
typically.
the special process server, is that someone that has to be registered with the state, or is that someone that the court authorizes to be the special process server?
They don't have to be registered with the state. It can be any person who is at least 18 years of age and not interested in the lawsuit.
Not a party to the lawsuit.
Right. Or have
So,
any interest in it, direct or indirect.
okay, so a person who um, is what a case the sheriff was unsuccessful, and they have a friend of theirs that they would like for that person to be appointed as the special process server. What does one have to do in this last minute? We're going to have to continue this because this is obviously gets more in depth. What does that person have to do in order to have a person designated or appointed as a special process server?
You would file a motion uh, for the appointment of special process server. In that motion, you would identify who it is you are asking the court to appoint and give some background information about that person. they're 18 years of age, uh, what their background is, where they live, or at least what their business address is, because then they become, in a sense, part of the lawsuit. Because if there's a claim by the defendant or any other party that they were not served, then you need to know who that person is, because there could be a motion to quash service that's filed, which suggests that the affidavit uh, of service that the special process server would create and then you would file is false. And therefore, court does not have jurisdiction yet because the defendant or other respondent in the litigation has not been served. And I've seen some fights over that situation regarding service that you would not believe.
I can imagine. So we can hire our own special process server. I thought that, and many people thought that the special process server had to be registered with the state, and in order to be a special process server. So learning something new, different.
No. In fact, in some landlord tenant situations, I've seen the landlord, plaintiff, if you will, through counsel or not, seek out another resident of the building to make service because they know when that tenant is there or not. So uh, it's not an extra effort on the part of that person to serve a fellow tenant because they're already in building and they know their comings and goings. And the other part is that they're likely to open the door for a neighbor,
Mhm.
not knowing that the neighbor is about to serve them with papers. And you
Um,
mentioned something a bit ago, and I know we're going to have to continue this discussion
mhm.
next week. But there's a difference between avoiding service and evading service. There's nothing in the law that says you must make service easy. There's no such requirement. So you can avoid service, but you cannot evade it. So, for example, if the sheriff or process server attempts to give you papers, it is in fact you cannot refuse to accept it. Uh, if you refuse, then they can say to you, your refusal, you've been served, and they can leave them somewhere where you can access them. But you cannot refuse to accept service, or at least it won't render that attempt ineffective. Uh,
Mhm.
you're saying, well, they didn't give the papers to me. Well, they didn't give them to you because you refused to accept.
Right. So, in other words, if they make actual contact with you and they can
Yes,
identify that it is you, and you refuse service, then that can be actually construed by the court as being service. That process, special process server comes to the court and says to the court, Your Honor, I saw um, Mary Jane on October the 5th at 3:54 at this address and attempted to give that person the um, the summons, and they refused to accept it, the summons. But I did make contact with them, and they just refused to accept it. So service should be, at that point, then the court will make a determination on whether service was met.
correct. Yep.
All right, well, folks, we're going to continue this conversation. There's a lot to unpack here and a lot to learn about the court process. We're going to continue this. We're going to put a note there because we want to make sure that we provide you with this information so that you are better equipped, so that if in fact, and when in fact, I should say, you have to go into court, you're prepared and you know what you have to do. Next week, when we talk about, when we continue this conversation, what there's some pet peeves of mine that I would like for you to expound on is how one should present themselves when they come to court, and does that make a difference? So we're going to talk about that next week on the next edition of the People Show. All right, that's going to do it for us, folks, tonight for this edition of the Legal Hour with Cook County Circuit Court Judge Leonard Murray. We thank him for being here with us every week here at 9 o'clock, and we're going to continue our conversation next week. Thank you so much, Judge.
Okay, Mark. Thank you.
All right, we will see you next week. All right, folks, so that's going to do it for us this week. I said to you that I was going to give you a story that about Donald Trump, and something that is a report that he was allegedly involved with a foreign country in terms of interfering with our elections. And there was a story that was done. If in fact it did happen, he will not be able to be found liable for this, or could be charged for it because the statute of limitations have run. But I think it is an interesting story. And so I promised you that we were going to hear it. And I want you to take a look at this story. Very interesting.
One of the first big lies Donald Trump told after announcing his campaign for the White House in 2016 was that his campaign would be totally self-funded. That, of course, was not true. Trump only self-funded about 20% of that campaign and turned to donors and super PACs to pick up the tab whenever possible. But at the very end of October, less than 2 weeks before the 2016 election, the famously cheap Donald Trump opened up his wallet.
Today I wrote another check for $10 million. I'm spending money like crazy.
Today, the Washington Post is out with breathtaking new reporting that paints that last-minute $10 million cash infusion in a whole new light. The U.S. government had classified intelligence indicating that Egyptian President Abdel Fattah el-Sisi tried to give Trump $10 million to boost his campaign at almost the exact same time. In September of 2016, candidate Trump, who was already calling for his infamous Muslim ban, met on the sidelines of the UN General Assembly for a closed-door meeting with the Egyptian president.
He's a fantastic guy. He took control of Egypt, and he really took control of it. And I thought it was a great meeting. We met for a long time, actually. We had a long meeting and got along. There was a good chemistry there. You know, when you have good chemistry with people, you're the king of that. And there was a very good chemistry, good feeling between us.
About a month after that great meeting, Trump gave his campaign that $10 million check. And then a few months after that, just 5 days before Trump was sworn into office, the Washington Post reports that a bank branch in Cairo received an unusual letter from an organization linked to the Egyptian intelligence service. It asked the bank to kindly withdraw nearly $10 million from the organization's account, all in cash. Inside the state-run National Bank of Egypt, employees were soon busy placing bundles of $100 bills into 2 large bags, according to records from the bank. 4 men arrived and carried away the bags, with which U.S. officials later described in sealed court filings as weighing a combined 200 pounds and containing what was then a sizable share of Egypt's reserve of U.S. currency. Now, there are a few incredibly important pieces of context here. One is that this kind of cash transaction being a potential bribe from the Egyptian government is very much within the realm of possibility. New Jersey Senator Democrat Bob Menendez was just convicted last month on charges of accepting hundreds of thousands of dollars of bribes in the form of envelopes full of cash, as well as literal gold bars. Cash and gold bars that came from Egyptian intelligence agents from the same agency involved in this nearly $10 million cash withdrawal. The other key piece of context here is that Egyptian President al-Sisi is not, as Trump put it, a fantastic guy. He is an authoritarian despot who overthrew Egypt's government with military force in 2013 and has stayed in power through sham elections since then. But despite that fact, President al-Sisi was one of the first guests President Trump invited to the White House and one of the first foreign leaders Trump met with on his very first international trip. Throughout all of his presidency, Trump cozied up to al-Sisi, despite al-Sisi's brutal crackdowns on political opposition and his blatant consolidation of power and his disregard for human rights. At one point, Trump was even overheard calling President al-Sisi his favorite dictator. Clearly, there is more than one. So all of this, the classified U.S. intelligence that al-Sisi tried to give Trump $10 million, the $10 million cash withdrawal by Egyptian intelligence outside of Cairo, all of this is red hot. So why are we just learning about it now? Well, the other half of this incredible new piece from the Washington Post is about how federal prosecutors investigated all of this for years. And then, knowing everything I just laid out, Trump's Attorney General, Bill Barr, seems to have made that investigation just go away. Back in 2018, in the middle of the Mueller investigation into Russian interference in the 2016 presidential election, the D.C. federal courthouse was filled daily with reporters looking for clues, looking for leads. But on December 14th of that year, something happened that made it decidedly much more difficult for those reporters to do their jobs. That day, court officials mysteriously shut down an entire floor of the federal courthouse, restricting access to both the press and to the public. Now, reporters assumed at the time that all the cloak and dagger maneuverings were related to Russia. But 2 years later, we learned it was about a separate investigation looking into whether the Egyptian government could have backed the millions of dollars that Donald Trump donated to his own campaign in 2016. And today, in an exclusive and deeply reported investigation by the Washington Post, we are learning about how a $10 million cash withdrawal at a bank in Cairo 5 days before Donald Trump was inaugurated, how that intensified that inquiry, and about the effort inside Trump's DOJ to bring that investigation to a close. Joining me now is one of the journalists who broke that story, Carol Leonard. She is, of course, a Pulitzer Prize winner and a veteran investigative reporter at the Washington Post. Carol, this story is not to be believed. Thank you for being here tonight. First, just, there are a lot of ins and outs, but as you understand it from your reporting, where do investigators, or where did they suspect this money may have come from, and where were they concerned it might have gone?
Alex, first off, thanks for focusing on this story, which was incredibly difficult to report out, involved a lot of sensitivity, including where I'll start the story, which is classified intelligence. The CIA basically alerted the Department of Justice in the early part of 2017 that they had information from an informant and other corroborated sources of intelligence that investigators at the time described as jaw-dropping. The intelligence suggested that the president of Egypt, Abdel Fattah el-Sisi, was planning and arranging to send $10 million illegally to help Donald Trump's reelection effort. You may remember at that time that there was this concern in Donald Trump's campaign world that after the Access Hollywood revelations, donors were backing away from him. He didn't have any money left. It was running on fumes, and his aides were asking him to write a big check of his own money to the account, and he would not do it. Well, in September, he meets el-Sisi, and at the end of October, he writes this check. What the intelligence suggested and what led to and spurred the Department of Justice investigation was that el-Sisi wanted to help Trump, who was even at that time promising a great relationship with Egypt if he was elected president, and that investigators needed to get Trump's bank records to try to figure out, did this money, mysterious money that they later learned had actually been withdrawn, just as the intelligence suggested, from one of the accounts linked to the Egyptian intelligence agency, Did this money withdrawn and put in duffel bags weighing 200 pounds in $100 US bills, a very large percentage of US bills then in the Egyptian currency of all of Egypt? Did that money that got withdrawn 5 days before Donald Trump became president, did it land in Donald Trump's accounts? From the investigator standpoint, they would never be able to answer that question, because as soon as they began proposing subpoenas to do this, the U.S. attorney said that she, Jessie Liu, needed to review this and brief the attorney general, a fairly new attorney general named Bill Barr. And within days of reviewing the intelligence herself, meeting with Barr, conferring with him, she returned to investigators and said she no longer believed that this was a good idea to subpoena Trump's bank records. The FBI was so angry that they began preparing their version of an ultimatum. Their view was, if we can't ever look at Trump's bank records, which are a pretty easy thing for federal investigators to subpoena, if we can't get those, then there is no chance in the world of us ever getting to the truth or the bottom in this investigation.
Yeah, I mean, there's so much here, Carol. And one of the things I'm quite interested in is, there's an aspect of money laundering, it sounds like, in here. I'll read an excerpt from the piece. Investigators saw hallmarks of an international money laundering operation in the way the funds moved into and through accounts ahead of the cash withdrawal, indications of a potential crime that may or may not have been related to an effort to help Trump. So there's the effort to help Trump. There's actually the source of this money. And then there's the investigation potentially being quashed. What stands out to you as the most, I think, disturbing element of what is already a fairly disturbing story?
I'm not the person to decide what's disturbing. I'm an investigative reporter. I learn a lot about how criminal investigations and sensitive intelligence is handled, but particularly sensitive criminal investigations involving high-profile people. And what my colleague Aaron Davis and I heard over and over again as we reported this out, looking at people's contemporaneous notes, looking at records from the investigation, reviewing documents that are still secret, Alex. What we heard over and over again was that there was chilling, jaw-breaking intelligence that pointed to a potential money laundering operation and an effort, at least by the Egyptian president, to bribe or compromise Donald Trump. And that when evidence was gathered by Mueller's team at the very end of the Mueller probe, when this evidence was gathered of this mysterious cash withdrawal of exactly the amount that El-Sisi apparently intended to give Trump, when that document was found, investigators thought, we have a lot of smoke here. There's got to be a fire. We've got to chase it down. But they were stopped.
Well, I mean, as you note in the piece, the statute of limitations has expired. The deadline for bringing charges under the federal statute of limitation for illegal campaign contributions expired, I think, January 15th of 2022. But it is hard to imagine with reporting like this that this story ends there. Carol Leonard, it is revelatory bombshell reporting, deserving much more deeper discussion. Thanks for making the time tonight. I really, really appreciate it.
And this is the guy who is convicted on 34 felony counts and has some 50 or 60 other felonies that he's been indicted on, as well as been found liable for rape and defamation and fraud. This is the guy who is the Republican nominee for the President of the United States of America. I wanted you to see that story. He will never be held to account for this, but this was the person who was serving in the administration, as well as his enablers in the U.S. Attorney General Bill Barr, who made that story go away. So we clearly know that we did not have a real independent U.S. attorney looking out for the interests of the American people. This is exactly the reason, or another reason, why it is important for us to protect democracy in this next election. Democracy is on the ballot November the 5th, regardless of what side of the political persuasion that you are on. If you care about the democratic process and about moving the country forward and improving the conditions of the country, then we have to make sure that these people don't get into power to continue to erode and to destroy democracy. That is what we must fundamentally be in agreement of. All right, that's going to do it for us tonight. I want to thank you all for tuning in to this edition of The People's Show. We'll be back with you on next Monday on intellectualradio.com for the Monday night edition of The People's Show. Next week, we're trying to get Adam Kinzinger, who is the former Republican United States representative from Illinois, who is, along with Jim Edgar, who is the former governor of Illinois, and they are rallying Republicans for Harris to be elected president November the 5th. We're trying to get Adam Kinzinger to come on to the program. We're also going to try to reach out to Governor Edgar to see if we can't get him to come onto the program and talk about why they are doing what they are doing. I think that will be a very interesting conversation. We'll keep you posted on that. All right, thank you all so much. I want you to go out and have a great week and have a great weekend. We're looking forward to the Democratic National Convention. Make sure you make phone calls and call all of your friends, all of your relatives, and make sure that they're registered to vote and that they go to the polls and vote. Now, also, let me give you some information, because I think that it is important that you have it before we go. I'm going to tell you some places that you can go to, and I hope I still have that information for you that you can check. Where did I put that information? All right, I don't have it here, but I will certainly have it the next. Oh, yes, I do have it here. If you want to make sure that you are registered to vote, you can go to iwillvote.com and you can check to make sure that you are registered to vote. And for people who are out of the country, you can still vote. You can go to votefromabroad.org so that you could get your absentee ballot that you will be able to send in. And you will get it by September the 21st that you can send in your ballot. So iwillvote.com to check your voter registrations to make sure that you are actually registered to vote. And for those who may be out of the country, you can go to votefromabroad.org to get your absentee ballot. All right, that's going to do it for me tonight. I look forward to seeing you all right back here next Monday on the Monday night edition of The People's Show. And again, we'll be back next Tuesday with Judge Murray for the Legal Hour. Have a great week.